Witherington. I practice in Tipton County, and in this case, I represent the appellants, Trey and Megan Davis, who are the parents of the child in this case. May it please court, I will give you just a brief overview of the facts because, of course, they are detailed and provide context in the case. This child was born in July of 2014. He was 4 years old when the dispute arose in this
Rebuttal?
case.
Did you want rebuttal?
I'm sorry, Your Honor. Yes, I would like to reserve 3 minutes.
3 minutes, thank you. Okay. Thank you.
His child was 4 years old when the dispute rose between the parties in this case.
Let me ask you a question.
Yes, sir.
Before we get too far into this, are the parents married?
Yes, sir, they are.
And were they married when the child was born?
They were not married when the child was born. They married after his birth.
And was it before this litigation ensued?
They were married before this litigation ensued. Yes, sir.
How does juvenile court have jurisdiction of this matter?
Your Honor, the juvenile court judge brought that up at trial. I did not file the petition, but his conclusion at trial was that because the child was born out of wedlock, even though the parties married subsequently, that jurisdiction in juvenile court would have been proper.
Does not their marriage take care of any out-of-wedlock issues as far as the child's concerned?
According to the statutes, yes, sir, I believe it does. That is certainly one way that the law says a child can be legitimated.
I don't like that term, but we use it a lot. But
Yeah,
anyway.
correct.
If the child is a child of the parties and the parties are married,
Yes, sir.
is there any way the juvenile court has jurisdiction of this matter?
Your Honor, under the statute, I'm not sure that it does, but the question was raised in the juvenile court, and the juvenile court decided that he did have jurisdiction. I think jurisdiction would be more proper in chancery court, but again, the judge determined at the time of trial that he did have jurisdiction based on the petitioner's argument that the child was born before they were married.
Isn't that the threshold question for us, though? The law on jurisdiction's pretty straightforward.
Yes, sir, it is.
If the court has no jurisdiction, then anything the court's done is essentially meaningless.
That's correct, Your Honor.
Isn't that the first question we need to resolve?
Yes, sir.
Okay. All right. Was that briefed?
It was, I did not address that argument in my brief, Your Honor. But if the court would request a subsequent brief on that issue, I'd be happy to file one.
Okay, we'll discuss that a little further.
Yes,
you may
sir.
proceed.
In August 2018, when this child was 4 years old, there was a significant dispute in this family. The parents had some reasonable concerns. They made some other child care arrangements, and in doing so, that did reduce the amount of time the grandparents spent with this child. After a trial, the court found that the parents had severed or severely reduced the visitation, that the parents opposed the visits, and that the severance or reduction was likely to occasion severe emotional harm and poses a danger of substantial harm to the child. These findings, Your Honors, are not supported by the evidence. They are against the logic of this case, and a preponderance of the evidence in the record and what was presented at trial leads to the opposite conclusion. We believe that the trial court did abuse his discretion here in making these findings because he applied an incorrect legal standard. The last finding in the court's order, paragraph 13, says, the court believes that it must balance the rights of grandparents to visit their grandson as detailed in the statute with the rights of parents' constitutional right to parent their child. No statute or case law contemplates any balancing act between a grandparent's rights and a parent's rights to raise their children. In fact, the grandparent statute is not for the benefit of grandparents at all. They don't have any rights to children. The grandparent statute is for the benefit of the child, to protect the child from substantial harm. That is the only way that statute would survive any kind of constitutional scrutiny. The only way the state can intervene in a fit parent's right to make a decision about their child is if that decision subjects the child to a likelihood of substantial harm. So in applying that incorrect standard, the court erred in two ways. One, finding that the parents severed or severely reduced visitation as evidence that they opposed the visits. They didn't oppose the visits. They did reduce the visits, but the case law says they absolutely have a right to do that. And also that the severance was likely to occasion this substantial harm or severe emotional harm. The proof in the record showed the opposite. There are no facts in the record to support a harm finding. Even the findings in the court order that support there are no findings in the court order that support that finding in any way. And the undisputed evidence at trial preponderates against that finding. To begin with,
let me ask you one more question.
Yes, sir.
I'm looking at the order for grandparent visitation.
Yes, sir.
From what I've reviewed, once the proof was concluded, the court took this matter under advisement.
Yes, sir, it
It
did.
did not render any oral judgment or any oral findings at all.
No, sir.
And the only findings of the court are contained in this 4-page order. Would that be accurate? Maybe it's 5 pages.
Yes, sir. Those are the only findings of the court.
So these are the entire findings of the court. Is
Yes,
that
sir.
correct?
Yes, sir.
Okay.
The burden on the grandparents to prove that the parents opposed visitation is that they must show there was either no contact or it was token visitation, meaning so infrequent, so minimal, it was so insubstantial contact with the child. But the proof in this case showed even after visits stopped as frequently as they were in January of 2019, they still visited with the child. The parents provided the grandparents the child's T-ball schedule, the school program schedule. They invited them to birthday parties. The child still interacted with these grandparents. Again, this family had a significant disagreement, and the parents made other arrangements for child care. The last night the child spent with the grandparents prior to the filing of this action was in January of 2019. The very next day, in the record, the grandfather texted the parents and wanted the same visitation back that they had before, which was they provided child care 2 days a week. And the response was, in the record from the parents, probably not. This schedule is working for us. Don't these parents have a right to make that decision for their child? They are fit parents, therefore presumed to be acting in the child's best interest. And the grandparents seem to, in this case, believe that because they had been allowed more liberal visitation in the past, that they were entitled to the same amount of visitation going forward. And this court has said, no, that is not the case. That assumption is misguided. And they also cannot rely on the grandparents' visitation statute to think they are entitled to more or different visitation in the absence of a finding that the parents effectively opposed their visitation. Here, these parties are arguing that they made 2 requests after the last visit in January of 2019 to visit with the child, and the parents said no. Therefore, that constitutes opposition to their visitation and standing to ask the court to intervene in their constitutionally protected right to raise their child and make their own decisions. And we think that the court should find that does not meet the burden, and the parents did not oppose visitation. Therefore, the grandparents have no standing to go further.
Did the parents offer alternative visitation?
The parents offered alternative visitation in that here's the T-ball schedule, here's the school schedule, here, come to the birthday party. He spent time with the grandparents for Christmas. He had an overnight visit.
No, I'm talking about after the visitation was refused.
The 2 times after the last visit, before the petition was filed, no, sir, I don't believe they did offer alternative times in those 2 instances.
Did they offer any subsequent visitation?
There was subsequent visitation offered and took place after the petition was filed. Yes, sir.
The trial court's order doesn't mention that, I don't believe.
It is mentioned in my facts, Your Honor, in the facts that I put before the court.
No, I'm talking about the trial court's order.
Paragraph 9 in the trial court's order, Your Honor, just talks
Okay,
about
you're right, I'm sorry.
after litigation, and they did set up some visits at that point.
Okay.
Even if the court here finds that the parents did oppose visitation, the grandparents still have the burden to prove that because of the reduction or severance in their relationship, it is likely to cause substantial harm or severe emotional harm to this child. It is a separate and distinct finding that the grandparents must prove. And the harm finding is the sole protection that parents have against pervasive state intervention in their parenting decision. Substantial is not a few teary goodbyes that the grandmother testified to. It is a real hazard, violent, extreme, or difficult to be endured. In this case,
Ms. Bartholomew, I know what's in the court's
Witherington,
order. I'm sorry.
That's all right.
Witherington. I know what's in the court's order, but what's in the proof in the record from the trial of this case as to substantial harm?
Your Honor, my client, the mother, testified that the child was thriving, was doing well in school, was participating in extracurricular activities, and was a happy and normal 6-year-old boy. The grandmother's testimony corroborated that, and when the specific question was asked of her, do you have any evidence that this child is suffering severe emotional harm? Her answer was no. That is the proof that is in the trial record here as to a finding of substantial harm. Essentially, in the court's order, because the court found there was a reduction or a severance of the relationship, it made a conclusory finding that automatically caused or could cause severe harm or substantial harm. And the case law says specifically that is incorrect.
Thank you.
All right,
Your Honor,
thank you.
I think my time is up.
We'll hear from you on rebuttal, Ms. Worthington. Good afternoon.
Good afternoon. I'm Julie Bartholomew from the Fayette County Bar, and I'm pleased to represent on appeal Randy and Holly Davis, who are the grandparents. I was not trial counsel, so some of the questions you may have about what happened at trial I may not be able to answer, but I'll do my best. Your Honor, as has been stated in my brief, the standard of review in this type of case...
Let me stop you. Do you want to answer Judge Stafford's questions about the jurisdiction of the juvenile court over this case?
I can only say, Your Honors, that I believe the issue was brought up, and Ms. Witherington was trial counsel, and I believe she has correctly answered that the issue was raised, apparently briefed, and decided before the judge took up this case. Other than that, I can't really answer that question.
And I appreciate your candor, first of all. I'm struggling with the issue of how juvenile court has jurisdiction. Do you have any thoughts, insight, belief?
I believe I did a little research at the beginning of that when I saw that issue come up. It's been such a long time now, I can't give you any specifics. Perhaps Ms. Witherington and I both need to brief that issue because it is a threshold issue, certainly. The jurisdiction, and it can be brought up at any time, so I understand why the court is concerned with that. If that can be resolved in the favor of there being jurisdiction, then of course we need to move on to these other issues.
Certainly, I agree with what you're saying. I'm just trying to answer question one before I get to question two.
I wish I could. I wish I could answer that question for you more fully, but unfortunately, that was something that had already been done before I got involved in the case, and since it wasn't raised on appeal, I didn't address it in my brief.
Okay.
As I was saying, the abuse of discretion standard does apply in this grandparent visitation case, and I would submit that there is a factual basis for all of the findings. I wish Judge Peeler had been more explicit in his order, but certainly the proof is there that supports it. He did identify the applicable legal principles that are required by 366306, and he also made a decision that was in the range of acceptable decisions, and therefore I believe that the court would be required to sustain his decision based on those matters. The finding that the court made about the opposing of visitation by the parents can be explained, first of all, by just looking at the answer that was filed by these parents. They admitted that during the 5 or 6 weeks between the last visitation and the filing of the petition, that there had been more than one request for visitation by the grandparents that were refused, and no other visitation was offered during those 5 or 6 weeks, no alternative visitation of any kind was offered for that 5 or 6 week period before the filing of the petition. In the brief, I go into more detail about other facts in the record that support the opposition, both before the filing of the petition and after the filing of the petition, that the court can rely upon as corroborating the opposition that happened before the petition was filed. So although that admission alone provides a factual basis, there are other factors that the court can look at in the record to see that opposition was properly found to have occurred.
Let me ask you another question, please. Trial court determined this visitation and explained how it was scheduling the visitation. In my review of the order, I can find no analysis of the trial court as far as the best interest factors that it was required to consider in working out this visitation. Is there something that I have missed, or did the trial court just decide this is the way it is and just not explain it?
I think the latter.
Okay.
I think he didn't explain himself in a way that would have been helpful to this court. So we're handicapped in that respect. But as I stated, I believe the proof itself establishes the reasons why he decided the way he did and why he found it was in their best interest. Under the statute...
Ms. Bartholomew?
Yes, ma'am.
I got the name right this time. Let me ask you a question. I'm going to ask you the same thing I asked Ms. Witherington. You say that there's a basis for the things that the court found. Well, the court found that there would be substantial harm to the child if visitation did not occur. What facts in the record was that finding based upon?
Your Honor, the facts that was based upon, as I pointed out in the brief, were almost identical to the same kind of facts that were found in the Couples versus Holmes case that the Western Section decided on May 31st. It doesn't have a citation yet. But the facts in those cases were almost identical to these, where the grandparents had been caretakers of the child for an extended period of time, that they had also engaged in other activities with the child outside of the caretaking, and that occurred the proof showed that in both cases. The proof also showed that there was a close and loving bond between the child and the grandparents, and there was recitation of facts involving where the child and the grandparents had a special saying that they said whenever they met or left each other, "I love you to the moon and back." One would say the first part and one would say the other. So all of that testimony was presented about the close relationship, about the extended contact, also about the child's anxiety when some visitation had occurred after the petition was filed. The court ordered some visitation to occur, and during that time, the child expressed whenever he had to leave the grandparents, he did become teary, he did cry, he was upset in leaving them. So that factor was also present in the couple's case. There was anxiety over separation and a happiness that was expressed when the child got to be with the grandparents, and those facts came out in this case. And then finally, in the couple's case and in this case, the child was 6 years old. And the court reasoned in couples that it would be difficult for the child to understand why he was not seeing his grandparents anymore and would have feelings of abandonment. So the anxiety, the feelings of abandonment were all present in both the couple's case and this case that supported the court's conclusion that it would be harmful because of the nature of this relationship, the closeness, the anxiety that the child suffered when he was separated from the grandparents in his young age. And so we submit that the same facts that were present in the couple's case, which upheld that grant of visitation, are present in this case. And it was considered adequate proof in that case, and I believe it's adequate in this case. Because there was no abuse of discretion in relying upon those facts that were found to be adequate in another case, I believe the court should affirm the findings of this judge that there was likelihood of harm to the child. I agree that it is a burden that has to be sustained. But in this case, the statute specifically says you don't have to have expert proof. You can rely on lay testimony. The only people that testified here were the two grandparents and the mother. The father didn't even testify. And as I pointed out in my brief, the court could rely upon the fact that he did not testify and give any kind of evidence at all as take a presumption that it would be adverse to him. Given all the facts that the court had before it, it found that there was harm to the child if the visitation was severed, and found that there should be some reasonable visitation afforded to these grandparents. That's all I have. If y'all have any questions, I'd be glad to answer.
Hearing no further questions, thank you, Ms. Bartholomew.
Thank you very much.
And Ms. Witherington, your rebuttal.
Thank you, Your Honors. First, I just want to address a couple of things that Ms. Bartholomew brought up in her argument. In this case, the court did not order visits pending trial. The parties agreed to visits pending trial. They were making an attempt to resolve the issue before the case was heard, but before the court. So there wasn't a temporary order entered because the court had absolutely no authority to do something like that. As far as the couple's case that Ms. Bartholomew mentions, the argument is that the facts there and the findings there are similar to this case. And I would submit to Your Honors, that's simply not the case, in my opinion. In Judge Akery's opinion in that case, he said that the trial court heard extensive proof and made extensive findings in its order, so much so that he couldn't even recite them, wouldn't reiterate them in the appeals. But in that case, the grandparents were the sole caregivers of that child for months. That is not the case here. In that case, the grandparents saw the child every day. That is not the case here. There was testimony in that case that the child's behavior had changed, that she seemed reserved around the grandparents when she didn't see them for a while. That's not the case here. There was no evidence or proof about the child's behavior changing. In fact, the opposite. The mother testified the child was thriving, doing well, and again, the grandmother corroborated the testimony. And as far as the father not testifying in this case, under the missing witness rule, it only allows the court to make an inference of what the truth may be. It does not amount to the court can't make a presumption based on that. It is an inference that cannot amount to substantiate evidence of fact. And, Your Honors, of course, this child loves his grandparents. He's happy to see them when he sees them. He's happy to see his mom when he goes home, too. That he cried a few times when he would leave, can that possibly lead any reasonable person to believe that that child is suffering severe emotional harm? Because if that's the case, 6-year-olds all over the country are suffering severe emotional harm every time they get a little teary when they have to do something they don't want to do. But that's not the evidence that the grandparents had the burden of proving in order to allow the state, the court, to impose its judgment on these parents instead of them making their own decision for their child. So in closing, Your Honors, I would just reiterate that based on the logic that the court used about this balancing act, that's an incorrect legal standard, and the grandparents didn't meet the burden that they are required to meet in order to have grandparents' time visitation.
Thank you
Thank you, Your
both
Honors.
for your arguments. We'll take this matter under advisement. That concludes the afternoon docket. We'll recess until tomorrow.
All rise. This honorable court stands adjourned.